Criminal law, mens rea. Intention. Most crimes consist of actus reus, guilty act, and mens rea, guilty mind. Mens rea in criminal law is concerned with the state of mind of the defendant. Examples of mens rea include intention, recklessness, dishonesty, and knowledge. Actus reus is all the elements of the crime other than those elements which make up the mens rea. Most true crimes will require proof of mens rea. Where mens rea is not required, the offense is one of strict liability. This video will focus on the mens rea of intention. Intention requires the highest degree of fault. A person who intends to commit a crime can generally be said to be more culpable than one who acts recklessly. It forms the mens rea of some of the more serious crimes such as murder, voluntary manslaughter, and Section 18 GBH with intent. Lord Bridge in R.V. Maloney, 1985, stated, "Intention differs from motive or desire. A person who acts out of a good motive may still have intention to commit a crime." In R.V. Smith, the defendant was liable as he had intention to offer a bribe. His motive could be seen to be good as he wanted to reveal the corrupt officer. Furthermore, a person who kills a loved one to end their suffering may well act out of good motives. Nevertheless, this does not prevent them having the necessary intention to kill. This was seen in R.V. Ingles, 2011, where a mother was found liable for murder when she killed her son on compassionate grounds. Intention is divided into direct intent and oblique intent. The majority of cases will be quite straightforward and involve direct intent. Direct intent can be said to exist where the defendant embarks on a course of conduct to bring about a result which in fact occurs. For example, D intends to rob a bank. To achieve that result, he gets a gun, a balaclava, he steals a car to use and then carries out the robbery. His conduct achieves the desired result of robbing the bank. Oblique intent is more complex. Oblique intent can be said to exist where the defendant embarks on a course of conduct to bring about a desired result, knowing that the consequence of his actions will also bring about another result. For example, D intends to kill V. He knows V is going to be on a particular aeroplane and places a bomb on that aeroplane. He knows that his actions will result in the death of the other passengers and the crew. In this situation, D is no less culpable in killing the passengers and crew than in killing V, as he knows that the deaths will happen as a result of his actions. The intention can therefore be inferred from his appreciation of the situation. The courts have struggled to find an appropriate test to apply in cases of oblique intent. In particular, the questions which have vexed the courts are: 1. Should the test be subjective or objective? 2. What degree of probability is required before it can be said that the defendant intended the result? 3. Whether the degree of probability should allow the jury to find intention or whether it is simply evidence from which the jury may infer intention. A subjective test is concerned with the defendant's state of mind, what knowledge they actually had and their thought processes. In relation to oblique intent, it would be concerned only with whether the defendant did foresee the risk of what occurred and the degree of probability of the result occurring from their actions. An objective test looks at the perspective of a reasonable person. Would a reasonable person have foreseen the consequence and the degree of probability of the result occurring from the defendant's actions? It is arguable that since intention requires the highest degree of fault, it should be solely concerned with the defendant's perception. Intention seems to be a concept which naturally requires a subjective inquiry. It seems somehow wrong to decide what the defendant's intention was by reference to what a reasonable person would have contemplated. However, originally an objective test was applied to decide oblique intent. In DPP v. Smith, 1961, the House of Lords held, D would have the necessary intention for murder if an ordinary responsible man, in similar circumstances, would have contemplated the end result. This position was reversed by Section 8 of the Criminal Justice Act 1967. This provides that a court or jury, in determining whether a person has committed an offense, a. shall not be bound in law to infer that he intended or foresaw a result of his actions by reason only of its being a natural and probable consequence of those actions, but b. shall decide whether he did intend or foresee that result by reference to all the evidence, drawing such inferences from the evidence as appear proper in the circumstances. The effect of Section 8 was considered in R.V. Hyam, 1975, where the defendant set fire to a house intending to scare the inhabitants, but unfortunately killed 2 of the occupants. The House of Lords accepted a subjective test was applicable. However, the majority decision of the House of Lords was out of line with Section 8, holding that foresight of consequences being highly probable was sufficient to establish intent, and the defendant's conviction was upheld. Lord Hailsham dissenting. In R.V. Maloney, 1985, the House of Lords corrected this error and followed Lord Hailsham's dissent. Lord Bridge reformulated the test on oblique intent. First, was death or really serious injury a natural consequence of the defendant's voluntary act? Secondly, did the defendant foresee that consequence as being a natural consequence of his act? The jury should then be told that if they answer yes to both questions, it is a proper inference for them to draw that he intended that consequence. However, R.V. Maloney left a problem with regards to the degree of probability required. This was considered in R.V. Hancock and Shankland 1985, where it was held the jury should be directed. The greater the probability of a consequence occurring, the more likely it was foreseen, and the more likely it was foreseen, the more likely it was intended. The degree of probability was still causing problems, and the cases of R.V. Maloney and R.V. Hancock and Shankland were reviewed by the Court of Appeal in R.V. Nedric 1986, which had similar facts to R.V. Hyam. The Lord Chief Justice, Lord Lane, reformulated the test. The jury should be directed that they are not entitled to infer the necessary intention, unless they feel sure that death or serious bodily harm was a virtual certainty, barring some unforeseen intervention, as a result of the defendant's actions, and that the defendant appreciated that such was the case. The defendant's conviction was quashed. In R.V. Woollin, the House of Lords largely approved of the test, with some minor modifications setting the current test of oblique intent, where the charge is murder, and in the rare cases where the simple direction is not enough, the jury should be directed that they are not entitled to find the necessary intention, unless they feel sure that death or serious bodily harm was a virtual certainty, barring some unforeseen intervention, as a result of the defendant's actions, and that the defendant appreciated that such was the case. In summary, intention forms the mens rea of many of the more serious crimes. It differs from motive or desire and can be direct or oblique. Direct intent needs no further explanation to the jury. For oblique intent, the Woollin test should be applied, and the jury may find intention only where they are sure that death or GBH was a virtual certain consequence and the defendant realized this. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.